Our criminal laws regarding drugs distinguish between personal and commercial quantities of the drugs. The distinction is important because the law recognises that a person who is merely a user of drugs is less culpable than a person who is involved in growing, manufacturing, distributing, or selling drugs. Much of our criminal policy around drugs is about interfering with the drug industry. In New South Wales at the time of this case, Section 23, subsection 2 of the Drug Misuse and Trafficking Act made it an offence to cultivate or knowingly take part in the cultivation of a number of prohibited plants which is not less than the commercial quantity applicable to prohibited plants, which for cannabis was 250 plants. Now, most of the time that's a pretty generous threshold, but in this particular case, the defendant, who was a user of cannabis, decided to grow some in his backyard. He was a bit haphazard about it and really just tossed a bunch of cannabis seeds into the garden in the hope that maybe a few of them might sprout. He then left his home, which was in Penrith, and went away to Canberra for work. The case doesn't really say how long he was away, but it seems to have been a reasonable amount of time. The cannabis seeds were not really tended while he was away, but they seem to have thrived on neglect, and when he got back, there was a dead-set tangle of cannabis plants in his backyard. Naturally, that's when the police arrived. When they untangled the tangle, they counted 281 cannabis plants which had germinated. So the defendant was charged with growing a commercial quantity. The defendant argued that the offence required mens rea, or in other words, that if there was no intention to have a commercial quantity of plants, the offence was not proven. The court did not quite agree. Justice of Appeal Scheller said that even in the absence of actual knowledge, intention may be proved by showing beyond reasonable doubt that the accused had a belief, falling short of actual knowledge, or was aware of the likelihood in the sense that there was a significant or real chance that the crop consisted of this number of plants. In this case, though, the number was pure accident. The defendant was convicted only of growing a personal quantity of the plants.